Welcome, everyone, to a special episode of the Federal Bar Association Ketam Sections, The Rounds, FCA News with Tejinder Singh. I'm Scott Oswald, Programming Chair of the Ketam Section, here with Tejinder Singh, who's a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
So we have done special episodes of the rounds after the Supreme Court took actions concerning various aspects of the False Claims Act, but this is the first time we've done so for a district court action, and that's because on September 30th, Judge Catherine Kimbrell Mizell in the Middle District of Florida, a district with a huge FCA docket, did something extraordinary. In U.S. ex rel Zafirov versus Florida Medical Associates LLC, which is a otherwise unremarkable FCA case, she held that the FCA and its 161-year-old Ketam provision is unconstitutional. So we don't need to go through all of the allegations. We'd like to just maybe cut to the chase here. Tejinder. Judge Mizell is a former clerk of Justice Thomas, and with this ruling, she seems to walk through the door that Justice Thomas opened in his 2023 dissent in U.S. ex rel Polanski versus Executive Health Resources, Inc., a head-on consideration of whether relators have a constitutional authority to file and pursue cases on behalf of the U.S. government. Judge Mizell concludes that relators do not have that authority, and she grants the defense motion for a judgment on the pleadings. If the 11th Circuit were to agree with her, well, we could have a reshape of our practice here for years. Before we talk about the implications of gender, can you briefly sum up the judge's opinion, which says that the FCA Ketam provisions directly defies the Appointments Clause of Article 2 of the U.S. Constitution?
Sure. So Article 2 of the Constitution has this clause, the Appointments Clause, that broadly speaking specifies how officers of the United States need to be appointed. That is, certain principal officers have to be appointed by the president, certain inferior officers can be appointed by the heads of departments. The clause actually doesn't say anything about Ketam relators or about what makes somebody an officer or not an officer. And so some judicial tests have developed around this. And the gist of the opinion here is not that the relator is an officer who was improperly appointed, really. It's that the things the relator does are the type of things that can only be done by an officer, and the relators conceitedly are not officers. Right? They're private persons who bring these lawsuits. And so the test that the judge applies in this case is that an officer is someone who exercises significant authority under the laws of the United States and holds a continuing office. And she finds both of those elements met. Holding that the relators have effectively the ability to initiate lawsuits, which counts as the significant authority part, and that they hold a continuing office because of their ongoing involvement with the case and ability to bind the United States. These arguments are somewhat novel. As you note, they first really resurfaced after Justice Thomas's dissent in the Polanski decision, but the judge accepts them here.
So, Tejinder, you represented one of the two amici who argued before her in April, along with parties. Tell us about the arguments that the judge rejected.
Sure. So if you read the opinion, there are some arguments listed there as arguments that the judge was not persuaded by. So, for example, the judge was not persuaded by the long history of Ketam statutes in this country, which dates back to and even before the founding. The judge was not persuaded by the fact that the Attorney General exercises substantial control over relators' actions, including having broad power to dismiss them, to settle them, to intervene and take them over. None of those arguments were persuasive. There are also lots of arguments that were made that weren't really discussed in the opinion. And these have to do with some of the practical implications of what would happen if you were to accept these contentions. So, for example, if relators are exercising core executive powers of the type that can only be exercised by federal officers, I think it raises a real question about whether hundreds of federal contractors are doing the exact same thing. Contractors are out there doing things, they're holding guns on the battlefield, they're collecting and parsing sensitive intelligence, they're policing the southern border. There's all kinds of, they're running the Medicare Advantage program. There's all kinds of things that contractors do that you could think of as potentially core executive power, at least as much as filing a lawsuit in civil court is. And the court doesn't really grapple with that. But the hearing in which these arguments were presented, it went on for several hours. And the court heard a lot from parties on both sides. And the opinion distills all of that down, I think, into a relatively brief summation that gives short shrift to a lot of the arguments in favor of the statute.
So, Tejinder, we're taping this discussion only a couple days after the decision. This is one district judge's ruling, not even binding within her own district, but it certainly has the potential to become law in the 11th Circuit and maybe even law of the land. The stakes obviously are enormous for members of our section. What happens next in Zafirov? What's the timeline at this point?
So there is obviously the potential for an appeal. I don't know if the relator in the United States, which intervened to defend the statute, intend to appeal. I suspect they do. I don't think this is the type of thing you would just let slide. So there is a 60-day period to file a notice of appeal when the United States is a party to the case, as it is because it intervened here. And so there will be a notice of appeal or two filed at some point. The 11th Circuit will set a briefing schedule and then ultimately hold oral argument. Depending on who the panel is, cases in the 11th Circuit, I've seen them take more time, I've seen them take less time, but it could be a while before we have clarity from the 11th Circuit about whether it's going to affirm or reverse in this case. If the 11th Circuit were to affirm, then I think you would certainly have a Supreme Court case. Once you have a Court of Appeals saying that a federal statute is unconstitutional, it's almost certain to go to the Supreme Court. If the 11th Circuit were to reverse, it is far less clear that the court would take the case, because in that scenario, there would be no circuit split, and so the case might end at that point. But it's really premature to think about what's going to happen after an appeal when the notice of appeal still hasn't been filed.
So let's talk about the implication and the meaning of this for current and future QTAM cases. This is a declined case, and although the U.S. ultimately intervened for the limited purpose of fighting the defense motion, as you read her opinion, does Judge Meisel's logic apply at every stage in the QTAM case? What do you think?
It's really not clear from the opinion. There are parts of the opinion that I think you could read to suggest that the mere act of filing the lawsuit is what violates the appointment clause. There are other parts of the opinion that really make it sound like litigating the case in the declined posture is what's bothering Judge Meisel. And so the opinion is not clear about the precise appointments clause violation. And so the short answer is we don't know for sure. That ambiguity is, I think, one of the things that's going to get argued about in future cases to the extent this case is relied upon as persuasive authority. But for now, I think in most other cases, if this issue is litigated, the starting point will be whether the broad proposition that there's any Article 2 problem is, that's going to be the crux of the debate. And then this debate around the margins about, well, when is it a problem, I think is going to be more of a sideshow in most cases.
So let's turn back to Justice Thomas and his dissent in Polanski. Justice Thomas recognized the possibility of a property interest, which might affect dismissal. In terms of Judge Meisel, what does she say on this subject, and what kind of attention does she give to Judge Thomas's opinion?
So the opinion breezes past this pretty quickly. I don't think that there's some question about, does the property interest survive Polanski when there's such broad power for the government to dismiss. Um, but I don't think that the topic gets a lot of attention. I think that the question of whether the government can validly assign a portion of its claim to relators was something the Supreme Court settled in the Vermont Agency versus Stevens case. And so, of course, the district court can't really take issue with that. And then the question that Justice Thomas raised was like, well, what is the basis for that assignment? Is it valid or not? That issue wasn't really litigated in this case, and I don't expect it to come up on appeal.
Let's talk about the implication of this here over the short term. No doubt defense counsel right now are firing up their motions to dismiss to add this argument and her ruling here. But let's just say a Ketam is filed in a circuit that is already determined that the False Claims Act is constitutional. What's your sense of the impact of this decision in those circuits?
None whatsoever. As you noted earlier, district court decisions are not binding precedent, not even in the district where they are decided, not even before the same judge who decided them. And so no other court has to follow this decision. Courts, of course, do have to follow the binding precedent of their circuits. And so when there is circuit precedent saying that the statute is constitutional, I don't think there's any basis for saying that that precedent has been overruled. It's possible that some of those courts of appeals will look en banc at their prior decisions at some point in the future, but I think it unlikely. I think this decision is currently an outlier and will remain such for a while.
So it's hard to ignore the fact that Judge Meisel's opinion has some elements in common with Judge Cannon's recent decision to dismiss the Trump classified documents case on grounds that the special counsel's appointment violated the appointments clause. The two cases are different in many ways, but they'll both be going to the 11th Circuit. Will you be watching what happens in the Trump classified documents case as that works its way through the 11th Circuit?
Oh, of course. I mean, I think everyone who's interested in this issue would be wise to look at any binding precedent about the meaning of the appointments clause. There's no reason not to consult those precedents as you think about what's going on here. But as you know, the two cases are really different. Ketam statutes have a unique pedigree. This idea about how much control the government exercises over relators is qualitatively different from what you have in the special counsel setting. And so there are a variety of distinctions that I think could be made, however the other cases decided. But of course, you have to pay attention to everything the courts of appeals and the Supreme Court are saying about the appointments clause.
Tejinder, are we watching this case as we record future episodes of The Rounds with Tejinder Singh? Thanks to each of you for joining us for this special episode of the Federal Bar Association Ketam Sections, The Rounds with Tejinder Singh. We'll see you next time.